So we will be getting started soon. So our agenda this morning, Belinda is going to lead us in a discussion to improve our mediation and facilitation techniques around good questioning and floating suggestions. That's something that's we've had some good discussions about when we've debriefed after some of the small claims mediations. And then Stephanie and I will do an update on the forms and review of some of the forms. There's been a lot of changes since we've gone to Zoom, and things continue to change, and we try to keep making it better. So we wanted to clear up any confusion around that. So with that, I thought we would just dive right into the agenda here. Belinda is going to lead a discussion on good questioning and talk a little bit about floating suggestions and how we can do that with and remaining neutral and without imparting bias into the discussion. So with that, I'll turn it over to Belinda. And just so you all know, I'll be monitoring the chats, so if you have any questions and you want to put them in there, but I'll also be monitoring the raised hands, so if you want to raise your hand, I'll be looking for that as well. So, take it away, Belinda.
Thank you, and great to see all of you. I really am happy I was able to make it today, not only to present, but also just to be with you all and not with no offense, but not with the folks at the court on Wednesday mornings, which I am often with them on Wednesdays. So let's talk about good questioning and actually what's happening in the cases in your experience that the questioning may be becoming a little bit complicated or moving people through the process towards resolution might have some bumps in the road. I just want to open up that dialogue, what you're experiencing. And in my time, and I know I have a limited amount of time, I actually have something to share on the screen. Gail shared some statements and questions with me that she's either heard or that were shared with her. And we just want to talk about it to make sure we're not stepping beyond the parameters of what mediation is about. Then I have some tips right from our training material and some other tips. Just some things to keep in mind from other trainers, Professors Joseph Stahlberg and Leela Love, who are highly respected in this field. And so I just wanted to bring some information that I put in a document and we can share, Gail can share it later. So just to get us started, oh, I cannot share my screen, Gail. Is that on purpose?
Try again.
Okay. Yep, it's there now.
Yay.
Thank you. So I'm going to go to the top of this document. I was trying to increase the font just so that everyone can see it. I hope you can see it on your screen. So we heard, Gail shared some statements, ideas, some examples of some things around questioning and getting movement. So I kind of took this from a perspective of that mediators in the course of mediation, you're trying to think quickly on your feet to move the conversation forward and getting people unstuck in their positions and not settling their dispute. So I just wanted to put this up here and hopefully generate some discussion and feedback around when this has been challenging or when you're thinking about using it. So checking on the range of ideas that have been considered. Have you ever thought about maybe returning an item, making an offer to complete something, splitting the difference? I think that happens quite a bit in mediation. People are so far apart, and one tactic that we use is sometimes just splitting the difference, and each person walks away with a little bit less or a little bit more than they came in and expected to either pay or concede on. Value of time, using that tactically as thinking about how much time it's worth to not resolve the problem in mediation, and keeping in mind that the small claims cases in particular, in many of our cases, actually are either court referred or ordered at this point. We're looking at about 90% of our caseload is coming from the court. So reminding people about their time and the cost associated with their court case, coming to mediation, maybe going back to court if it's not resolved. Taking responsibility, asking the question about what do folks really feel responsible for in their role in the dispute is how I'm interpreting that. And then also making the suggestion, and I think that's the tricky one, when mediators are finding it or believing that it's helpful to make a suggestion of a dollar amount in the course of the negotiation, and is it appropriate for us to float a number? So just based on this, and there may be other examples that are not listed here, and if you want to throw that in, please do. But let's take maybe a few minutes, 5-10 minutes, and just talk about what's happening in mediation that's prompting this. What do we think? Is it too much, not enough? Or as a mediator, I am getting frustrated when folks are close to resolution and then they just hold their position and not make the necessary movement. What do you think is happening? And we can just popcorn, and anyone who wants to chime in, please do. Yeah, go ahead, Alexandria. I see, and I can't see everyone's hands because I'm sharing my screen, but so you might just have to jump in.
Well, this past Monday, as you know, I'm getting back into it, and I'm learning from Andy and Al. Thank you very much to those gentlemen. We had a case where one of the parties would absolutely not budge on the amount, and it was a fairly straightforward amount, which to me was almost a no-brainer. And we tried floating, we didn't float a number, but we tried saying, well, the other party is willing to compromise, can you come along, that sort of thing. Mm-hmm. And it is, and I won't say I was not frustrated in any way, because I'm glad to be back in the game. But I thought I could not come up with another idea to make this person want to think about trying to settle, because we were very, very close to a settlement. The other party had already given us a few ideas and was still flexible. Okay. And it really was a question of the other party just holding out for the principle of the thing. And I know you know what that means, the principle of the thing, because the money wasn't even that much. I mean, it was almost, to me, it was almost pocket change that they were arguing over. So any suggestion about how to break that deadlock when somebody just refuses to budge?
Yep. And we're going to talk about that in the next, after this piece of it. Anyone else? And thank you, Alexandria, for just sharing that lived experience. I'm not in the room or on Zoom with mediations anymore, so I and the staff are working remotely, so sometimes I'm not hearing a lot. So thank you for sharing that.
Can you address the question, is it ever appropriate for a mediator to float a number? And is saying splitting the difference floating a number? Okay.
Yep, we will talk about that. I'll get other comments first, Kathy, and then we'll go back to that. Okay. Thank you.
Thank you.
Anyone else?
So I'll just say Kathy and I were on one, I think a week or so ago, where they were absolutely rigid, but very close. And we did, I'm not sure we floated a number, but I think, trying to help them understand that this is going to be, get this out of the way, get this done with, you don't have to go back to court. I mean, none of that was helping them, I think, until he said, you are $200 apart. What if you did something, which actually broke the log jam, but I think Kathy wasn't very comfortable with that. So that was one of the reasons we're talking about it, I think.
Okay. That's great. That's great to hear. Any other comments?
I know that sometimes we have parties who have had a personal relationship. And so sometimes building the future of that relationship can help move them off the dime.
Yeah.
But it goes back to, you know, what you will be talking about is how do you phrase it so that
Yeah.
right.
Yeah, and I think that's the tricky part. Like, we can see it right there in front of our faces that we've been listening so well, we can hear things that maybe they're not hearing from each other. So I'm giving you all kinds of stars because you're hearing things that they're not hearing, which means that you're really listening. And listening, as we know, is a part of the art of mediation or whatever, facilitation or restorative circle, whatever we're doing. We have to be able to listen, and we are hearing information that others may not hear because they're stuck in their positions, or they're thinking of how to stay stuck. They're thinking of their counter argument. They're thinking of their rebuttal, or they're shutting down. And that's what happens when people are in conflict. And it feels to me that for several years now, even before the pandemic, many of our customers, their conflicts, even in small claims court, is a bit of a crisis moment for them. There's a lot at stake for them personally, maybe their family, even if it's a smaller amount of money being sued for. So I think we have to keep that in mind, but I also want to just lift up that you're listening. Before I move on, are there any other comments? Again, I can't see but a few boxes on my screen when I'm sharing, so I don't want to speak over anyone.
Yeah, Belinda, just to piggyback a little on this first one, which I think is a great question, something I learned in another training, which I've found works really well, is to phrase it in the form of, would you be willing to do X, Y, or Z? Just saying that phrase, would you be willing to do this, works amazingly well sometimes to get people off square one.
Yeah, it's a great thought, and framing, using those questions and how we frame those questions is very important. For those of you who took your training, and I think most of you took your training at the DRC at some point or another, I want to encourage you to go back to your manual, and even if you took it with a different trainer, go back to the manual, because I think all of the trainers have very similar ideology in content in their manual, even if it's organized in a different way or may have more words, or to suggest an idea or in their technique. In the DRC's manual, in section 4, we actually have that section talks about good questioning and listening, and it's called drawing out information. And we talk about listening and questioning. And I just want to remind you of a few things about questioning. We want to rely on those open-ended questions. So questions that allow the parties to give more content, because that means we have more intel that might help frame other questions that will lead them down that path of resolution. What are the concerns? Could you tell me more about that? What else happened? And if you're in that space of negotiation, it might be backing up a bit and remind me of why this issue is important to you. Remind everyone at the table or on the screen what's concerning you the most about this particular issue, and let them talk more about it. Sometimes, though, we do have to be a little bit directive in our questions. And I'm thinking if people are becoming so principled, as Alexandria mentioned, we might need to be a little bit more directive. So in a caucus, we might want to ask a question like, explain this further. Help me understand the position that you're taking. Maybe I missed something. Help me understand why you're holding the line at this dollar amount, or whatever it might be. What is important to you about this issue? Maybe they weren't able to, the party may not have been able to articulate that very well in the joint session, but you might be able to probe a little more in a caucus to get more content around it. So far, even with those kinds of questions, we're giving the conflict back to the party. We're reminding them that this is their problem and it is their responsibility to work towards resolution. But through our probing and questioning, we can help them sometimes unlock that position and move forward just in the way that we question. Reframing. Remember, reframing is a part of our toolkit. We hear information, and I think that's what Susan was saying. Have you ever thought about, and I can't remember exact words you said, Susan, but how do we reframe that to get that point across, that there's an idea out here or a concept out here that might help you, and we want you to think about it. So instead of saying, you know, think about this concession or think about that proposal, let's talk about this a little bit more, and what more do you need to understand about this proposal? What is the missing information from it? Would you like to talk more about this privately in this caucus, to just explore maybe the pros and cons, to explore the reality of that proposal? So giving the parties the space and time to do further exploration of a proposal that is on the table, or even an offering that they have made but didn't fly. Maybe there's something more about that offer that they can do. We have to make sure that we're letting the parties exercise their own agency and feel empowered around these offerings and proposals, even when they're angry and they feel stuck or there's no way out. Also in mediation, and we talk about this in our training too, we expand the pie for them. So there may be, beyond the dollar amount, are there other options that you would be willing to discuss as a way of resolving this dispute? Maybe there's something that a person can tack onto it. So I owe them $200, and in a business dispute, I owe $200 and I'll do the next project for free, or something like that. That, you know, depending on the business, depending on what the case is about, but there may be an and that can be tacked on to a possible resolution. Ruth, I see your hand.
What you're saying in the last several minutes reminds me that a question that I like to use in caucus, particularly if the parties have been unable or unwilling to suggest something, to take the first step, is go into caucus and then ask, when you were on your way over here today, did you think about anything that you might offer to get this settled? Because that way it's totally what comes from them rather than my suggesting anything.
Mm-hmm.
And usually people acknowledge that, yeah, they had something in mind, but they weren't yet willing to share that with the other party.
Mm-hmm. Thank you, Ruth. I think that's a great example as well. Karen, your hand is up. Karen, yeah, Karen. I think we only have one Karen here. I was going to say your last name too, but I don't need to. Sorry about that.
This is really basic, but what is a caucus? Is that different?
That's the private meeting where we take one party and the mediators work with one party at a time in a private meeting, so to speak, to address whatever it is that they want to address. We do it with each party, and then we bring everybody back together to move to the next step.
Thank you.
Thanks, Karen.
When you mentioned something beyond the dollar, I'm reminded of it was a small claims case that it settled on a quart of honey. And that was by far the sweetest case I ever dealt with. But, it was not something I would have ever known to bring up, certainly.
Mm-hmm.
But very often there is something beyond. Another one was when somebody really just wanted an apology. And once that apology had been expressed, we could move on to work through an agreement.
Yeah. So just expanding the pie and adding on and what else are you willing to consider, or would you like to discuss that might help you feel comfortable in moving towards resolution? It might be enough for people to think creatively and outside the box. I know that with small claims cases and civil cases, money has been identified in this lawsuit. So let's be reminded that conflict is not always just about money. There are other unmet needs. People are having a conflict because there are unmet needs, and because of the way our court system is designed, if a lawsuit is filed, the court is expecting some sort of monetary dollar amount. So a lawsuit, I'm suing, someone sues Belinda to make her apologize, is not something that the court can even enforce. So it's not a lawsuit that they would even consider. So the person suing me will be compelled to put a dollar amount there, which could be very arbitrary in nature, but it will get my attention and it will get me into the court system or a mediation. So as mediators, we have to be mindful that there might be an and something else, but let the parties define that something else. It's not up to us to define it. And through the listening, you have heard some things, you have heard the emotions that these parties are carrying. Maybe that is, information, or I call it intel, that can help you question and help them discover that and. You seem so bothered by this. You're very upset about this. The other party has offered some money, but it doesn't seem to be satisfying you. What else is there that is upsetting you about this dispute? What am I missing? What didn't I hear? Let's talk about it and give them that space and time to really unpack and talk about that emotion, which, we may think of that as a separate piece of the mediation process, but it can be directly tied to the outcome, how people are feeling those emotions that they're bringing into the case. Splitting the difference, we've talked about that as a tactic in a training. In all the trainings I've been to, and I've been through Zena's training, Susan Butterwick's training, a woman named Nancy Klein, who was my professor way back when in grad school, and they use that tactic very often. So I think that it can be something that is helpful. But how we do it and the placement of it, I think, is critically important. So in some cases, it might be this question of you are $500 apart in your negotiation. These are the numbers that I have listed here. Let's talk about that $500. How do you want to resolve that? Would you like to explore the option of splitting that difference? And just giving them that idea, planting that seed, that idea there, I think might be helpful. But I do acknowledge that kind of anchors them. Splitting the difference in most people's mind would be a 50-50 split. For most people, $250 less or more in their thinking. And so how do we frame that in a way that allows that whole $500 difference be on the table for negotiation, for further negotiation? How do we distribute this difference? Is there a way to talk about what this $500 can represent for each party if you want to spend more time there and not just quickly move into splitting the difference? And keep in mind that you can caucus. I know that might be a little bit more challenging in Zoom. In person, you can ask a person to step out in the hall and that kind of thing. And I think, and I'm wondering, I don't want to assume anything, but I'm wondering, because we're in a Zoom space, are mediators feeling a little bit hurried to get off Zoom or to get the parties off Zoom? Or if the parties are saying, hey, I only have a few minutes or something like that. That has happened to me a couple of times, and I really hate when that happens. Hey, I have to leave in an hour, and we're just 15 minutes into the conversation, and no one said that earlier. And it makes me feel a little anxious around time. And that's just something that I deal with. When people give me a time limit, I get really anxious. So we have to think about that as well. Can you use caucus? Should I talk about the splitting the difference in a caucus, a private meeting, or should we do it here in the full screen with everyone here? But generally speaking, I think that tactic can be useful because we're helping people see something. Maybe for the first time, we're helping them discover that that difference is not such. If you're talking about $5,000-$6,000 lawsuit or more, $500 may not be too much of a big difference for them. Yeah, Ruth?
If you just add, if the sentence is, have you considered splitting the difference in some manner? If you just add this in some manner, then it implies that it doesn't have to be 50-50. But
Exactly.
Yeah,
Thank you for that.
Yeah.
Thank you for that. That's why I wanted to have an open discussion because I don't have all the words in my head all the time. Valuing the time. I think that's a very good tactic. People become more invested in the argument and not see the big picture of the time. You were ordered to mediation, but your case, if it's not resolved, it will go back to the court, and the court will decide what will happen next. Think about the cost associated with the time. What would you like to talk about that? You know, just framing it as much as possible as a question. Would you like to think about what the value of your time and the cost and logistics of getting prepared for another hearing, to be more detailed around, you know, in painting a picture that something more is going to happen. You're not going to go before the magistrate tomorrow and make your argument in 10 minutes and then get a verdict. You're going to be scheduled for time at the court's discretion. I think it's helpful, and it's just a reality test for them. Is there any part of the amount that the plaintiff is asking for that you feel responsible about? I think that's a great question, actually. Let's talk about taking ownership and responsibility of what you're hearing, and let's talk about, you know, slowing the train down enough to talk about what that amount is to you. The plaintiff has $1 amount in mind, but the defendant may have another dollar amount in mind if they're willing to take responsibility for it. So even with that question, is there any part of this conflict that you want to take responsible for? And if so, let's talk about ways to resolve it. So even if you remove the dollar amount out of that question, it widens the pie a bit and gives the defendant an opportunity to respond to the issue at hand and not be reactive to the plaintiff. I hope that makes sense. So let's move away from this person has no business suing me and they're lying to, yeah, I was there and this did occur, and maybe I'm willing to talk about how we can work this out together. And there's something in the chat. Gail, is this something I need to pay attention to now?
Nishun was just asking if we could stop the screen share, I guess, so we can see other people's faces.
Okay. I could do that if that's okay with everyone. So that, take that responsibility. And then I want to get to Kathy's question about, is it appropriate to float a number? And my in our training content says, let's not float a number too soon, because floating a number anchors people in that position. So if you say, what about $200? Then people are going to stay stuck in that $200. And then they might say, well, the mediator said that $200 was enough to resolve this case. And even though that is not the intent, but it gives a perception that you have made some evaluation of this case and you're offering a number. So that's my reaction to floating a number. If it's a number from them, and I heard you in the session, I heard you talk about $1,000. do you want to continue talking about that? Is that an offer you really want to make as a solid offer, or we need to explore it more? And exploring it might be, what are the pros and cons? What are the logistics? How real is that? Is it even possible to do it? Would the other party is willing to accept it? All of those things that go along with it in floating that number. But I want the mediators to refrain from that, because you begin to anchor these folks, and you might make them more polarized. So now the mediator is saying, my situation is only $200. How dare them? This was, a loss to me of $600, and I want my $600 back. So that's the risk that you take in floating a number. And floating a number is a little different from looking at the difference of positions in terms of the amounts that they've given, and looking at how to distribute that. So again, given the behavior of the parties on the screen, and I'm not sure what you're experiencing there, I think in my much limited experience, I see people a little bit more bolder because they're virtual, a little bit more polarized because they're virtual, and I do a very separate kind of case than the civil stuff. I'm seeing that behavior, that posturing more, and maybe you are too in the small claim setting as well. And we have to live with this for a little while longer. But if you can stay away from floating that number, that would be my recommendation, so that you're not taking responsibility of that outcome. Does that answer the question, Kathy?
It helps a lot, thank you. But if you do get stuck, is it advisable to, say, well, have you considered splitting this 50-50?
Yeah, have you considered another number? Have you considered moving up a little bit? What is the implication of you increasing your offer? What is the implication of lowering the offer? Really open-ended, and letting the parties, let them sit in that space for a while to see and feel what negotiation is all about. That's what negotiation is about. Give and take, concessions, increasing, decreasing. It's really an important part of the mediation experience. And in a lot of ways, we're teaching people how to negotiate. And you may not have signed up for that, but we're giving people, teaching them some tactics around how to think about their issue, how to look at a bigger picture, how to increase the pie by having an and not an or, and what it means to really have good faith bargaining and interest-based bargaining. And even if we have to back up and remind them of elements of their opening statement, what the issues are that they identified. Does this proposal tie back to that issue? And does this proposal help them feel satisfied with an outcome for that particular issue? It's okay to do all of that even in Zoom. I know that's what we talked about in training. That's what our role plays are about. In-person mediation, it may have felt easier because we have the flip chart there, and you can point at numbers and put more stuff on the flip chart. I miss the flip chart. I really miss it. I like the flip chart and the multiple color markers because I think it really helped give people a focal point, which might mean we need to think about how we use Zoom. We do have a whiteboard in Zoom. I don't know how prepared the staff are, but maybe we can talk about that. I have been in a Zoom meeting where I could use the whiteboard and type as a participant and have my stuff typed on the whiteboard. I'm not sure how that lady did that, but there are some techniques out there where we can use the whiteboard and have that visual, because maybe that's a missing technique for the mediators, is having that visual for people to kind of see where these proposals are floating. And if you've heard multiple proposals in their discussion and you can type it on the whiteboard where they're thinking there's one or this or that, and you've heard 5 different possibilities that they didn't even hear because they're positioning their argument. They're not really listening to each other. That might be something that you can take back into mediation. And maybe we can have some practice time. I know Stephanie talked about some more Zoom, training, for the lack of a better word, and maybe we can explore that option too. Did I see someone's hand? Oh, Phyllis, your hand. Yeah.
I think when you mentioned the whiteboard, I did like the flip chart as well, because it was a nice visual way of separating out what was that request for $3,000 based on, and it could be broken down into segments. And sometimes I think when the parties see it broken down into the segments, then maybe they can negotiate further what the financial settlement would be, because it can be more concrete. Well, okay, the steps really were there anyway, so we can delete that from the list, so forth.
Yeah, thank you. I think maybe we and we'll talk about this as a staff, Gail and Stephanie. How do we kind of make the whiteboard a tool for the mediators during the session? Okay, so and also I want to remind you from the training how to get movement, just some things to rethink. Testing the options. So you've been listening to folks, you have those 5 options. It's not just yes or no. We have now other options. Test them out. Take the time to review them. Having that list, weighing the pros and cons and the logistics of it, what could really work, I think is helpful. Negotiating standards, really looking at the substance, assessing the constraints, asking the parties to establish those priorities. Parties are arguing about different things, but what are the priority issues here? What are the things that we need to be concerned about? Because sometimes people just enjoy the argument. We have to remember they're in crisis, they're in conflict. And some folks, and I remember this, my history at the DRC, people enjoy the argument and having that platform, that private space where they can let the other person have it. We have to really take control of this set process and ask, and you might want to ask that question, what are our priorities here? What would be the goal? What is our goal today? Take them back to the beginning of the process. The BATNA and WETNA, the best alternative and that worst alternative to the negotiated agreement. We've talked about that in the training. That is a technique that has been tested by mediators throughout the country. That is a part of the negotiation book of getting to yes and getting past no. Joseph Stahlberg, which I have some comments from him, is one of the authors of that book. Reinforcing and enforcing your ground rules. If people are polarized and they're not negotiating and they're acting out, because I imagine if they're not negotiating well, they're escalating their behavior. They're becoming more pointed maybe. Maybe they're using language that is not appropriate. Remember to enforce your ground rules. If people are being hostile, you may have to address that and get them to focus on those issues. And when they're making progress, compliment them. Acknowledge that you've heard them. Acknowledge that they're frustrated. And acting out on your frustration is not really helping this process. You might want to say that in caucus. So how do we get back to working on the issues at hand? What do you think you can accomplish today? And giving them some agency and ownership around that. Power balances, I don't know if you're experiencing that, if people are, for the civil cases, not small claims, but if one party, I'm just noticing through checks that come in for the civil cases, it looks like one party may have an attorney, the other party doesn't. Actually, I laugh with Stephanie Myers, I said, wow, because I'm at home and you hear these TV commercials of law firms, I am just in awe of some of these law firms are sending in mediation fees to the DRC. And how sad is it that people are retaining these lawyers who have ads on TV and settling their dispute with the community center. I just find it such an irony in that for me. But I appreciate the work, and that's the work that we're here to do. But I find it interesting. But it does present a power imbalance. I have, some big time lawyer off TV helping me with my dispute, and the other party may not have that. So we have to figure out how to deal with the lawyer. If they're there for counsel of their client, let them only counsel their own client. They should not be negotiating with the other party or influencing or escalating that negotiation with the other party. They're acting as a lawyer in court, and we are here in mediation. And I've said several times using the caucus and framing your statements as questions. So for all of this, if your statement is framed as a question, you are halfway there. Think about the content of your question to make sure you're still working as a facilitative mediator and not giving advice or evaluating the case. And just a few things, reminders about for mediators. Joshua Stahlberg is a professor of law. He's really kind of impressive. I was one of his students at Wayne State when I was studying dispute resolution, but back in 2015, he provided some other content for training, and he was at Ohio State University at the Michael Moritz College of Law. I think I said that right. And Leila Love was at the Cardozo School of Law, and both of them are highly respected people. And they were also very instrumental with our state court administrative office in getting mediation off the ground here in Michigan. And I was looking through some of their material and thinking about today, and I thought this was worth sharing with you all, that as mediators, we can't get despaired when parties remain oppositional. It's their problem, and it must be their solution. So if they're not willing to do the work and cooperate with the process to reach a resolution, that's okay. And if you've been in a training room with me, I say, I don't care about how many settlements we get. I care about the experience that our community members have when they're in session. And that's really important to me, because I believe that you plant seeds that no court system can plant, and they may resolve that dispute before the hearing date. We have had magistrates to talk about that, like the case got canceled. We set the hearing date, then they adjourned it or they canceled it, or they were miles apart when they came to court, and then they went to mediation, and when they came back to court, they were inches apart. That is still true. And that's because of the work that you do inside of that room with them and helping them to frame information, to hear things differently. And you've given them some tactics around negotiation. They may not actualize it in the room with you, but they may do it later before that next hearing. They've had some things to think about when they leave you. As mediators, we have to be flexible. So what I've described this morning requires flexibility, going into those caucus spaces, putting a person in a waiting room, however you set the caucus space up. You may have to do that multiple times for those more hostile parties, those more entrenched posturing parties, the very principled parties. We may have to caucus with them. And if you caucus with one, you got to caucus with the other. And I know it's a whole thing all by itself, but we have to be flexible. And just understanding that people are bringing so much more to these cases than maybe before the pandemic. There's still a lot of stress and despair, and our society is very polarized, and they're angry. And even though this is a $50 small claims case, they're bringing a whole lot of other baggage with them. So we have to be flexible. Relying on those techniques in your training, if it's worth reviewing your material, if you have some downtime and just thumbing through it, making some notes, conferring with your co-facilitator. Maybe you hear a question that you've never heard before. Write it down. Make it a part of your toolkit. When I am listening to circle keepers and they ask a question, I'm like, that's a good one. I write it down because it's a good one. And it's something that we can all use. So these are, this is our tool, our toolkit. So we should be sharing that with each other. And remembering that mediations is not always a miracle. Sometimes the movement is slow. It may take longer. When I just ran our data reports a few weeks ago for the state, and I think our average time for mediation across all the mediations that we do, so family, any mediation that occurred in circle, because we factor that in too, we were still running about 90 minutes a session, average time. That's not bad. Actually, that's very good. That's only 30 minutes more pre-pandemic. For a long time, our average time was 60 minutes. And some of our cases, a small segment of our cases take a whole lot longer, hours and hours, family cases, divorce, we know that. But because of small claims and the civil things, they bring that average down, that number down. And so we have room. If it takes you a couple hours, it takes a couple hours. That's okay. If it takes a little more, if it takes another session, that's okay. Don't worry about it. And movement could be slow. And the last thing I'll mention is that there are no guarantees. Because we do facilitative mediation so well, we know that there are no guarantees for a resolution, because we give that responsibility to the parties. We're not telling them what to do. And there are some mediators that actually tell people what they need to do. You need to go ahead and settle this and take that offer because that's the best you're going to get. We do not do that because we're not supposed to do that. We do not own those agreements. It's their agreement. So that means sometimes there won't be agreements, and that's okay. And right now, as of our last report, and this has been pretty true, we've always had a really good settlement rate. And right now, across the board of everything that we do, we are at, 71% of a settlement rate, which is really good. Since my time at the DRC, I think our lowest was probably like 65% or something like that, which isn't bad either. Anything over and beyond 50% is really good. And we're at 71%. And I think that's really good. And when we did the compliance review earlier in the year, we were like 85% compliant. So people are at 85% of the time, people are doing what they say they're going to do. That's really, really good. That's impressive. This is the kind of data I take out, to courts and, folks, partners and all of that. And they are like, really? Yeah, that's the work. And that's what the data is telling me. That's not anecdotal. That's real. We have to pull cases and make phone calls to know that compliance rate. So you all are doing really, really good. Really good work. So thank you for this time. And the last thing I want to say, if I can, just to give a shout out to mediation. Mediation is really doing well. Oh, the compliance rates for the court. Last I heard, Greta, it was still around, it was 50% or below, depending on the court, because they have to do their satisfaction survey. And pre-pandemic, they were doing it very well. So I don't know how it's working in this pandemic, but they had to do surveys, and the satisfaction rate was 50% or below across Washtenaw County. So, and I don't even know what compliance means to them. They were just measuring satisfaction. So you can, read that a few different ways, I guess. So I just wanted to talk about a shout out to mediation, something that we do in the community at a community level, really is gaining momentum in some of the harder cases. I don't know if any of you heard, but the Charleston 9, the South Carolina AME church, where 9 people who were worshiping lost their lives to a person who had come to the church and killed them, basically. The criminal case is over. The Department of Justice, Merrick Garland, took on the civil case and settled the case using mediation as one tactic. There may have been others, but mediation was one tactic. And they settled the case for $88 million for the surviving families of those 9 people who were killed. And that caught my attention as like some morning news, headline news kind of thing, that mediation was a part of structuring that settlement, negotiating with the families, with their attorneys, and one of the attorneys in the case really praised how the mediators, and he named them, and there were a team of mediators, and he named a few of them, how gracious and kind they were to these families who had lost loved ones during a prayer meeting at church. And without the mediators, he really did not think there would be any settlement, and he certainly didn't think that number would come. But it was the mediators and the role that they played and the grace and the comfort that they gave to the family members that was important. And it also compelled Merrick Garland to also address the family with his condolences and personally, and how important that was. So I just thought, in addition to the families feeling some measure of support from the federal government, there was something got missed in the assessment of the shooter when he got the gun. It was something like that led to the civil case. And it just warmed my heart to know that mediators are exercising such a high level of humanity and helping people reach resolution. And I just wanted to share that with you all too. So that's it for me, unless there are other questions.
Any questions for Belinda? Well, Belinda, thank you so much. It's always just love to hear you talk and always learn so much from you every time. So thank you for joining us and taking the time today. Really appreciate it.
My pleasure. So I'll get this document finished, getting it cleaned up a little bit, and I'll send it to Gail and she can distribute it.
Okay.
Okay.
All righty. Thank you. Thank you. So that was like a fun, juicy discussion. So now we can talk about forms. That'll be fun, right? Yay, everyone's favorite topic. But let me just share my screen a little bit. So what, we've had a couple of questions, and there have been so many changes. Well, I will just go down. So many changes in the forms. When we moved to mediating on Zoom, that caused us to change the form. So there's been lots of changes, and then there's continuing to be changes. And I know it can be frustrating and confusing for you all with the different forms and the different processes that the different courts have in place. And Steffi and I do our best to try to not make that any of your problem at all. So, and Steffi and I are working together, and I'm new staff and trying to streamline our processes a little bit. And I really do appreciate feedback and suggestions from you all. So kind of the good news is that Stephanie and I will be using the same consent to mediate form. We had been using some different ones, but I'm adopting the one that Stephanie's been using. So when you mediate with me, basically the content is the same. It's sort of wordsmithed differently. Probably the one big thing that's different is this one, number 7 here, where it says that the DRC may disclose the details of your mediation agreement to the court. And that would just be in the example, in one of Stephanie's courts, they do include some of the details of the mediation agreement. And that could be true in my courts as well if there was a consent judgment. So that's why that line was added. And that's kind of the only sort of big change other than wordsmithing and kind of rearranging things, making it flow a little bit better.
Could
so,
you,
yeah.
could you clarify something on the form that's always troubled me? If you go down right there, number 9, the parties agree that information obtained will not be used in other legal proceedings. I mean, for example, if during, I can see all sorts of interpretations. And one is, let's say during this proceeding, there's information that the party has other assets or has committed other torts. So now you have new information. I mean, does it mean strictly that you could not say that you said in this proceeding that you had done such and such and are therefore liable? Or does it restrict that information that's been discovered to say, oh, the only reason I know that he has all these other assets or that he committed this other crime or whatever is because I heard about it during this proceeding, during the mediation, and therefore it is not admissible in court?
I'm gonna, go ahead, Belinda.
Yeah, so if I'm hearing you correctly, Michael, the participant, that's number 9, agreed that information obtained would not be used in other legal proceedings. That's a statement that we are encouraged to make in our consent form by the State Court Administrative Office, because the court rule indicates that mediation cannot be used for discovery. So even if that party goes to court and says, well, I heard this or that, the judge is supposed to strike it and not admit that information because of the confidentiality rule. The only exception to confidentiality are things that are along the lines of harm, violence, or illegal things. And so that duty to report is not necessarily with the other party as well. That is the exception for the mediator. But in terms of what participants or lawyers hear in mediation, they are not supposed to go to court and share it because mediation cannot be used for discovery.
Well, I'm just wondering, what if they just, now they've heard about this other stuff going on and they decide that, oh, I'm now going to independently pursue this and not use that, go back and say, well, they said this in mediation, but now I have new knowledge and I'm going to use this knowledge to discover that really there are all those other bank accounts or there's this other activity going on.
And if they do that, and it's, we can't control what people do outside of mediation, but if they do that and then they want to subpoena the DRC record, because you're on the board, I'm going to say our job is to protect the integrity of our operation and not produce those records. We will fight that subpoena.
Right. That would be.
And that's another reason why we ask mediators to destroy their notes when the mediation is over. So even our handwritten notes can be, and we don't leave them in the file, and the staff and I talked about this on Monday. We don't want any notes, handwritten notes in the file for that reason.
Yeah. No, I understand that in terms of our records. I'm just questioning,
what the parties might do outside of mediation.
What the parties might do outside of that, and if they're saying, if they are agreeing that they won't, I mean, and I don't know how they can't not use information that they suddenly find out about during mediation. I mean, I don't see, it's confusing to me. I don't know if it is to the parties. Occasionally people ask about it, and usually not. But I'd like, I don't know, I'd like to have it clarified myself.
I don't know if other mediators are experiencing this, but basically this statement number 9, and actually all of the statements in this consent form are aligned with the policies and procedures of the state court administrative office and the court rule around confidentiality in the entire civil mediation and domestic relations mediation court rules. So we have not invented anything that we could not defend.
No, I mean, I know, I understand that, but I guess I'm just like it looked at, but maybe the court or
yeah, and to my knowledge, I mean, to me, if to my knowledge, I have not heard any legal challenge to that. Like outside, people learned something in mediation, and then they went and tried to do something else with some information that they heard that was not the exact issue that they went to mediation for. I haven't heard any challenge of that. I think that might be a good question for the state court administrative office if they've had any challenges to that ever in the state of Michigan. But at the community centers, we have not.
Okay.
Alexandria?
Yeah. Belinda, I have an idea, because I understand what his question is saying is that once a person has heard information, they're not going to forget, especially if it's to their advantage. What if you change the word "the participants agree" to just "the participants are made aware" that information obtained will not be used, and that's telling them that you're not allowed to use it whether you need it or not?
I think we can consider that, but I would want to go back to, we are heavily governed by the state court administrative office, and I want to make sure we're always in compliance because we also get audited. So I just want to make sure that we're okay to get through an audit. And that's a little bit of my ego because we have passed every audit that I've been a part of. So, and I want to keep that scorecard going. Again, I can certainly am willing to take it into consideration and go back to the policy manual and make sure that we're not stepping out of bounds.
I think one of the advantages is that we want them to know that they are not able to do whatever they feel like with the information they get. So it's not so much that they're agreeing as that we are telling them this is what you're going to do. Okay. And that might be a little bit stronger statement. That's all.
Okay.
Yeah.
Okay. Ruth, you have a question or a comment, Ruth?
Well, I was just going to say to differ a little bit from what Alexandra just said, because I think if we're not only telling them, but the participants are actually agreeing that the information contained will not be used, is even stronger. So I guess I would suggest that the parties agreeing to not use it is stronger.
Okay. Any other comments or questions or concerns about the mediation consent form?
I was just going to share that, Michael, I had a case years ago where that statement stopped the case cold because the information you find out in mediation, it can't be unheard. And if there are other issues going on, if there's other cases with one of the parties, they wouldn't want to sign the consent form because they could find out information or even information they knew beforehand can be prevented from being used in this next case. So it's a very difficult legal question. And Belinda is well advised to check in with the state court system on this. But that one stopped this mediation dead cold, which could have been resolved otherwise.
Yeah, and I'm going to say that that's okay. You heard enough as mediators to make that judgment call, which we have to rely on you to do that. We have the reality that some things are going to slip through because the courts are looking at whatever court documents that have been filed. Somebody in the court makes a quick assessment and says, yes, let's use alternative dispute resolution. Let's send it to mediation or case evaluation or an arbitrator. They're making quick judgment calls. So it stands reason to me that something might get to us that probably should not have. because the parties of the case are not all, most of the time, are not having a dialogue with the judge or the judge's judicial attorney or the supervising clerk. They're not having those kinds of conversations to even know, for that staff person to even know, well, mediation would not work because there are these other issues. So I'm glad that you caught it. I'm glad that you, you checked it out and made sure that it made sense to stop the mediation and let the parties go. That is completely okay. And the other thing I would say is that that is happening so few times that I didn't even know that happened. I mean, it happens so few times that it's not enough to create worry. This is still considered a voluntary process. Even when people are ordered, there are some counties where people come to their ordered mediation, they sign the consent to participate, and then they don't talk. They have satisfied the order by showing up.
The thing about the mediation consent form is that it's an automatic on everybody's part. And so nobody really explores the nuances of the statement.
Mm-hmm.
So when you get to number 9, I mean, it's a ticking time bomb, but it doesn't register necessarily. So you go ahead and sign the form.
Yeah.
Mm-hmm.
That could be it.
In all the years, I've only had that question once, that one time, where the guy was really paying attention. He said, "What do you mean I can't use it? I got this other lawsuit going on."
Yeah.
And it wound up, it stopped it right there. I mean, the guy refused to mediate.
Yeah. Well, I'm glad that he was paying attention, and it must be, a big lawsuit, or at least something that had a high stake for that individual. So
Yeah.
Good for them.
Diane and Jennifer Wolf, you had some comments in the chat. Did you want to expand on those? Diane? Nope. And Jennifer Wolf, I think she may not be able to talk, so I will read her.
I can you hear me?
Yep, we can hear you. Yep.
I have so many delays on my phone. I'm really sorry. It's just a bad feed. I always just explain that the context of that, and I just say, just so that you know, if you don't settle today and you go to court, nothing that's been discussed will be admissible in court. And then I always add, if you try to bring it up, because you forget and you mention it, the judge will stop you and you won't be allowed to discuss it. And I think it just kind of frames it. Also, I use that as an opportunity to say, if you're going to work really hard in mediation, just know that you'll have to start over if you go to court. So back to the value of their time too. So I don't know if that's good or not, but I haven't had anyone object to that clause.
Thank you. That's helpful. And just anything else on that consent form? We're kind of running out of time, so I just want to hit the highlights of the other. Stephanie and I will also use the same mediation agreement form, which is very simple and straightforward. Yeah, it is. So here it is. Yeah, it just has one statement, and then the agreement, and then the verbal agreement for virtual signatures. So this was a different format, but we've standardized the format for that. And then when it starts getting, any comments about the mediation agreement form? When it starts getting tricky, and Stephanie, feel free to jump in here. I support 3 different courts, 14A1 and 14A4, and those 2 courts have similar processes and similar forms. And then also 14B, which is an Ypsilanti, which has a little different process. In 14 and 14A, 1 and 4, if we reach an agreement, they use a dismissal form. Whoops. That is used for if there's a mediated agreement, if there's a default judgment where the defendant does not show up, and also for a consent judgment as well. So they use that form. So we provide a copy of the dismissal judgment form to the parties and a copy of the mediated agreement. That judgment dismissal form is sent to the court, and then in about 2 weeks' time, it's signed by the magistrate, and then the court also provides a copy to the parties of that form. Then in 14B in Ypsilanti, we provide the DRC dismissal form that some of you all may have been more familiar with. So this is not a standard form from the state. It's one that we created, but Ypsilanti likes it. So that's what they want us to use. In Ypsilanti's case, if an agreement is not met, the party would be required to refile the case, but they indicate on that refile that it's a refile of a prior mediated case, and then that case would be sent directly to it would be assigned a court date and sent before the magistrate. So even with a mediated agreement, there's no slam dunk if there is non-compliance with the agreement. In 14A 1 and 4, if there's non-compliance with an agreement, the party has to sign an affidavit of non-compliance to start that process to get the mediated agreement enforced. So I'm going to turn it over to Stephanie to talk about her 2 courts and what's different or similar there.
Hi. Okay, so my 2 courts is 15th District, which is downtown Ann Arbor, and then the 53rd District. The 53rd District Court is the Livingston County Court. Sorry, my kid's out on COVID quarantine from class.
Oh, no. That's okay.
So those are my 2 courts. The way that the 15th District handles a dismissal, so if there is a mediated agreement, how they do a dismissal is actually a consent judgment form. So the consent judgment form is a unique form because it actually is a dual form. It can be used as a consent judgment, or it can actually be filled out as a dismissal. So with the 15th District Court, if there is a dismissal, we will use that consent judgment form, but we will fill it out as a dismissal. It can also be filled out as a consent judgment, and you would do that in lieu of a dismissal. So you either do a consent judgment as one avenue, and the second avenue would be a mediated agreement with some form of a dismissal. With the 53rd, they created what they call a conditional dismissal. This is unique to the 53rd District Court. We actually, Belinda and I worked with the clerks over there, and we actually created this with them when we started offering them services last year. And the 53rd District Court was concerned about, well, what if we have parties that go to mediation and they enter into a mediated agreement, but then somebody breaches the agreement? They don't follow through with whatever they agreed to do. Then what would happen to the non-breaching party? Would they have to file from scratch a new case? And that is actually how it plays out in the 15th District Court. Well, the 53rd District Court said, well, that doesn't seem right. That doesn't seem right. How can we work around that? So they created this conditional dismissal form. And what the conditional dismissal form does is it basically dismisses the case once the condition is met. And the condition is usually the payment plan in a lot of small claims cases. So Bob agrees to pay Laura $500 by November 5th. So in the conditional dismissal, we just put just that payment structure, whatever that conditional terms are, that's what we put in the conditional dismissal. And that's why you saw in the consent form, we said may share the details of your mediated agreement with the court. That's the only portion we're sharing with the court. It's just that conditional language that triggers that, not the content. So the whole conversation and the personal things that were shared and all that, the content of the mediation discussion is confidential. Just that conditional agreement part would be shared with the court. And that's what triggers the conditional dismissal. So then when that condition is met, Bob pays Laura by the set date, then that case is dismissed. But let's say Bob doesn't pay Laura. Well, now Laura has some protection with that conditional dismissal. Now, language in the conditional dismissal says if the condition is not met, Laura can go ahead and file with the court a affidavit of noncompliance, and there's no new fee for that. She's not going to be charged a fee to file that. She can go back to the court, fill out that new form, and it's going to bring the case up right where it left off. They already went to mediation, so where it left off is now they're going to have a hearing date before the magistrate. The magistrate's not going to hear the whole case from the beginning. We already have a mediated agreement. The magistrate at this point is just going to hear the conditional dismissal language. Did Bob pay Laura $500 by the 5th? Yes or no? No. Ordered against him. And that's all there is to it. Does anyone have any questions about that? Okay. All right, that's my 2 cents. Thank you.
Thank you so much, Stephanie. And we try not to make you all worry about this, but you know, it does come into play during mediations when we're explaining the forms, and you all see different forms for different courts. And a lot of times I know folks, when I'm mediating, you're not even really aware what court you're mediating for, which is fine because you're not really there. So we are coming upon 1 o'clock, and I'm a big stickler for ending on time. I really want to appreciate and thank everyone for joining us today. It's so lovely to see you all, get to know some new faces. I'm so happy and pleased with some new faces joining us for small claims mediation. We've got a boatload of cases, so really, really appreciate the new faces that we're seeing, and certainly appreciate all the regular folks. As I get to know you all even better, you are just such fun, smart, kind, and generous people, and it's a real privilege to work with you and get to spend time with you. So thank you, thank you, thank you. And with that, unless Belinda or Stephanie have anything to say before we sign off, I hope everyone eats a lot of Halloween candy and enjoys it. And call us if you need anything. And hopefully we'll see you next month, if not before. Thanks so much.